And it's time now for another edition of our Debt Relief Program with attorney Ziona Kopolovich, who's in the studios live with me this 17th day of April 2013. And welcome back.
Well,
pull that towards you some there. Yeah, that'll move around.
It's so good to be back here.
Yeah, well, from what I hear, you almost didn't make it back.
Well, it's always an adventure for me.
Which way do you come up from?
I come up the
Parkway?
Parkway, yes.
So you turn left instead of right, huh?
I continued. I made it all the way to 98, and let me see. About a month ago, I
it's
took
easy. It's easy
275 to 75, and just kept going.
It's easy to miss the Brooksville exit.
Oh yes, it is
because it comes up on you so quick. I mean, I've noticed that in driving up it, but of course I know. So you just kept on going till it ended.
I mean, yes, I think one day I'm going to end up in southern Georgia. That's what's going to happen to me. But
we're glad you got here on time.
Of course.
Because it's always good to talk to you. And for those who haven't heard the show before, we have new listeners every day. The attorney, Ziona, we just call her Ziona. Ziona Kopolovich is I guess you're a bankruptcy attorney. I hate that word, but it's a real world in the real world,
It is a real area of the law, bankruptcy law.
And she calls her company, by the way, in case you haven't heard, Debt Relief Law Offices. So as I was talking about a few minutes ago, you've got these, looking for debt relief, and the bankruptcy is something you're thinking about, got it on your mind, can't make up your mind. This is the lady to talk to, and she'll talk to you for free right here, right now at 796-7272, or you can use 277-5919, or toll free from anywhere on the Nature Coast at 1-888-613-2050. She'll also talk to you for free at her office for a consultation.
That is correct. If you want to call me at my office, it is area code 727-849-3328, and Shannon is there waiting for your phone call.
Shannon's there. There's a song, Shannon. Remember the song, Shannon? She probably does.
Well, she may be too young for that.
You know what? I don't know how young she is, but she might be, because it was a long time ago. And most of the time, for those who haven't listened, when we're going to have a caller first thing here, Ziona, so you're going to want to get those headphones on. We talk about Chapter 7, Chapter 13, and deciding which of those kinds of avenues is best for you and your situation. But let's go to this first caller.
Okay.
Obviously, they were listening earlier. Hello, you're on the air with Ziona.
Good afternoon.
Good afternoon to you.
Yes, I have two questions maybe you can help me with.
Okay.
The first question is, can wages be garnered for unsecured debt?
We have to look at Florida law, and we're not talking bankruptcy law here. If you're a wage earner, you're the head of the family, then your wages are exempt, anything under $750 per week. So that cannot be touched. You're looking at Florida Statute 222, and that gives you the different exemptions that you have. Also, 6 months of your income as a wage earner are exempt. Now, that same exemption is used in bankruptcy law. So, in general, your wages cannot be touched by creditors. That's very generally. But you have to go and defend it if you're not in bankruptcy.
Yeah.
You have, if they garnish your wages, you have to go and assert that exemption.
Because they'll get it if you don't go defend it.
Right. So,
go
ahead.
You mean if you don't go defend it, but my wages have not been garnered yet.
Okay, well, in order for your creditor to go after your wages, they will have to file a lawsuit, and then once they get the judgment, then the next step is to go after your wages. They'll have to serve you. They'll have to let you know when they file a lawsuit against you, and your employer will know before you when they intend to garnish your wages.
File for garnishing.
Right.
Will the employer know when they file, or will they know if it's granted?
when the employer usually will call you in and tell you, look, in the coming 2 weeks or so, your next paycheck, I'm going to have to.
Okay. So they're told after the garnishment is granted.
Yeah.
Yeah, but he gets notified that there's going to be a garnishment hearing ahead of time. Right?
He can ask for that hearing.
Okay.
He can ask for that hearing to contest it. But if was a judgment obtained against you for a debt?
Yes, they were. It's unsecured debt. It happened through a divorce.
Mm-hmm.
Okay.
And,
It
Doesn't sound unreasonable.
well, I mean, if you want to come in to my office, bring your information with you, financial information and all that. I'd be happy to sit with you for an hour. We give an hour free consultation, and we'll review that and look at the options that you have. And then you can decide what you want to do about it. Now, you said you had 2 questions. What's your second question?
Yes, ma'am. The second question is there a statute of limitations on unsecured debt? What for credit cards and
That's
things?
a good question, actually. I like that question.
It is a good question. Usually, after, I think, about 10 years or so, they're not supposed to go after you, but they do. And again, these are rights that you're supposed to assert. If you don't assert it, then they'll get a judgment. So nobody's there to defend you if you don't defend yourself or hire someone to defend you.
So if I guess the judgments would, are you referring to a judgment where, like the credit cards companies have sold it to,
they sold it to collection agencies, right? And they'll go after you, and it's up to you to go to fight them back. So you can either do it individually, face each and every creditor individually, or you might as well, just what we do, we file a bankruptcy, and just it's cheaper and quicker, and you get everybody. At the same time. I mean, you don't have multiple litigations. You don't have to go back to court either every few months or every few years each time a creditor surfaces. So just one.
Good. So, but I think I missed it. Is there what the statute of limitation is in effect even though there's a judgment, or would there be one?
No, not if there's a judgment.
Okay.
Yeah, judgment have longer lifespans than just a debt.
And believe me, they're not going to just sit there. These people, if they get a judgment, they're not going to just sit there.
Yeah.
They're going to come after you.
I believe that. Yes, sir.
Believe me, I know.
Okay. Well, thanks a lot. I appreciate it.
You're very welcome.
I will listen for your number, for your business, for your office.
Okay, I'll give it to you right now. Do you have a pen?
Yes, I do.
Okay, it is 727-849-3328.
And you'll get to talk to the famous Shannon. Yeah.
Wow.
Right.
Yeah. There you go.
And that's good. And it's 1 hour is a free consultation. Did I hear that?
That is correct.
Well, that is wonderful. And thank you so much for taking my call.
Very welcome. My pleasure.
All right. Thank you, caller. Good questions. 796-7272. You're welcome to call. She'll be glad to answer what you can. She deals mainly and almost exclusively in bankruptcy, right?
That is correct. This is our main bread and butter.
And what you were trying to tell him, and I hope, and I'm sure he's still listening. And I like to say this as often as I can because people are still under the illusion that bankruptcy is the worst possible thing you could do. Your credit's ruined for the next 10 years. And you've explained to us that's just not true over and over. And I explained it again why it's not true, because it makes common sense.
Okay. Well, your credit is determined by your credit worthiness and the risk that a lender takes in loaning you money. So if you have a lot of debt now and your debt-to-income ratio is really not that good, then that means that you're poor credit risk. Even though you may have been paying your debts all along, you might get to a point where you can no longer pay your debts.
And the ratio is what you're talking about. That's bad.
Of debt to income.
Yeah.
Correct. Now, if you file a bankruptcy, that ratio becomes wonderful because you have income, but you don't have debt.
Right.
And then the chance that you will fail on an obligation is much lower because you just cleared up your credit. So it takes, after filing a bankruptcy, it takes generally 1 to 2 years. a year to 2 years to clear up your credit, for your credit score to rise again.
And people need to understand that, because we've been, the very first show you taught me that, and because I was one of those under the illusion that you're done for the rest of your life,
No,
you're
of course
ruined,
not.
and everything's...
Of course not. No, a bankruptcy gives the honest but unfortunate debtor a new lease on life. Just clean up the old debt, put your life back into a viable financial posture, so you can deal with lenders and you can pay your debt.
And see, that's important, because it makes sense what you're saying, that the lender, after the bankruptcy and after it's all straightened out, a year or 2 years, and they're looking at you and you've got all this income and no debt, the ratio is pretty darn good that they're going to get their money back.
Right. That's right. And people do want to pay their debts.
Sure they do. Most people.
Most people, yeah. Most people do want to pay.
Yeah.
Most people want to pay their debts. There is a sense of pride when you are able to pay your debts. For all of us. So when people do file for bankruptcy, in most cases, it is the last step. There is just no other place to go. They don't make enough money to pay the debts. The circumstances are such that they either confronted illness or some kind of a financial disaster,
whatever it was, yeah.
loss of a job, an accident. It could be a number of factors that would come in to cause a situation, bring about a situation that you cannot make good on obligations that you have taken. So bankruptcy is one avenue that is quite effective in helping you restructure your financial life.
Yeah, and stop the phone calls.
Stop the phone calls.
Stop the phone calls.
You give them my phone number, and they get to talk to Shannon. They get to talk to Shannon.
And then they talk to you.
And then they talk to you.
And the phone calls will stop magically.
Magically, that's right.
Well, it's not magic.
So
actually, it's hard law.
We file Chapter 7s, which is, people sometimes call it straight bankruptcy. We help you get rid of unsecured debt. Generally, if you, for example, you own a home that is severely underwater, you lost your job, you can't make your mortgage payments, you've got to get rid of the house, but you can't sell it because you are severely underwater. And the market isn't there now. So we file a Chapter 7 for you. You walk away from that mortgage obligation, the taxes, everything else that came along with the house. You walk away from it. And there is no tax penalty. So you just walk away from a debt. The IRS stays away. The mortgage company stays away. Your credit card companies stay away. And you're a happy camper.
Yeah.
Right?
Exactly.
And that clears you up to when you find a new job to buy a new home in the future. It really does clear you up for a new mortgage. It takes about 2 years to get over that. Now, Chapter 13 is for people who either have assets that they have to protect, or they may have an income that forces them into paying a portion of their debt back. Or sometimes, if you're behind on your mortgage, we can help you catch up on arrears on your mortgage. We can strip off a second mortgage or a HELOC, a line of equity loan on your home. We can do that through a Chapter 13. Very, very good mechanism for you to be able to, again, get your financial life back on the right road.
Well, another good mechanism to get that debt to income ratio back where it belongs.
Back where it belongs.
Yeah.
Now, sometimes we have clients that don't want to file a bankruptcy, but they're able to make some kind of a reduced payment to their creditors. So we're happy to negotiate unsecured debts down to where our clients can afford to pay them. Usually it requires a lump sum payment, a reduced lump sum. So I can tell you that generally we can bring your unsecured debt down to about 20 to 35% of what it used to be. If you have the money to settle, that's a great way to go. And we're happy to do that for our clients.
All very interesting. And now today, and we only have 9 minutes left, so believe it flies, doesn't it? This time just flies by. If you want to call, you're still welcome to, but you said you had some more stories.
Yeah, well,
and I want to hear them because the last ones were great.
Well, the story this time is not. It's not any of my cases, but I found its story to be very interesting. It comes to us actually from Orlando.
Okay.
A debtor filed a bankruptcy, filed a Chapter 13, and part of the Chapter 13, they went through mortgage modification. So,
okay.
That was actually...
And then we've talked about that mortgage modification, good part of it.
And that was with Bank of America, and they agreed on a mortgage modification. They signed the agreement. The judge ratified the agreement. They made payments, and lo and behold, 2 months later, they get a letter from Bank of America. Pursuant to your request, we're canceling the mortgage modification. The problem was they never requested to cancel the modification.
Yeah.
So it started a circus, really, between with Bank of America,
I bet it did.
Where the lawyer for the defendant or the debtor is saying, we're not canceling. We want that mortgage modification, and Bank of America totally ignoring it. In fact, Bank of America increased the payments, kept sending letters demanding money. The debtor went back to court asking for protection, which they got from the court. Bank of America is not reacting. Once again, raised the mortgage payments, raised the escrow, was not applying the payments that the debtor kept saying, was not applying them to the principal, but just kept the money.
Wow.
They went back on unassigned funds. They just kept the money aside, did not reduce the mortgage balance. They went back to court a second time, got a second order against Bank of America, stop collecting, ratifying that mortgage modification again. No response from Bank of America. Finally, the judge got so upset with Bank of America that she issued an order, first of all, fining Bank of America by some $220,000, which was almost the amount of the mortgage. And the other penalty was saying that if the Bank of America does not respond again within 30 days, this order should be, once recorded, would constitute a satisfaction of the mortgage. So what do you think? Did Bank of America respond this time?
Well,
One guess.
No.
Yes, they did.
Okay. I mean, I don't
penalty
understand.
brought them out.
That brought them forward.
Yes, they did respond. So now we have a response, and we're waiting for the judge's decision. Bank of America is saying we were never notified properly. But once we heard that there is a problem, here we are responding. And
how can they make such a statement?
Well,
I guess
with
that's
a
why you should always
face.
send this stuff registered mail. Always send it registered mail.
And that's what Bank of America was saying, that they were entitled to a certified mail notification, not just a letter. So we'll see how Judge Zinnemann feels about that.
And can I give a vote?
Sure.
I say he gets the house and they can take a walk. This first of all starts with that mortgage modification. What, did somebody upstairs just decide that they were going to declare this man made a request to have the mortgage modification stopped?
Rescinded, right.
Where did that come from?
The attorney for the debtor has documented emails, conversations, letters to Bank of America. So they were communicating with some people, but apparently not with the
right people.
The right people.
Yeah.
So that's pretty interesting. So we'll see if that homeowner out of
when
Orlando
do
gets
we
to
expect the decision on that?
I don't know. Hopefully, when I come back in 2 weeks, I would
love to know how that comes out.
I may have some news to report on that case.
You can even call me ahead of time.
Just to give you the heads up.
I'll be curious on this all the way till it comes, because you get tired of dealing with those kind of people. Like, we're so important, that we ignore your letters and we don't care until the judge says, okay, I'm going to fine you $220,000.
And I'm going to give the house away.
Yeah, and I'm going to give that person the house.
Right. Both of them.
Wow.
So that definitely did bring Bank of America out of where they were hiding.
Yeah, and did he ever get an answer? Or did he ever ask, meaning the attorney for the the debtee, me, if that were my
debtor?
The debtor, is that what we're called?
Debtor? You have the debtor and the creditor.
Where they got the idea that he wanted the mortgage modification stopped, where they came up with that, I mean, that would drive me crazy.
I don't have the answer to that, and that answer is not on the docket.
Why wouldn't his lawyer ask for that? I want to know.
Well, I don't know that he didn't. I cannot tell you whether he did or didn't. That is not reflected in the court
court case. But I'd love to know. I'd love to know exactly how that happened. Because, somebody's sitting up there saying, well, let's just go ahead. The heck with the mortgage modification. We agreed to. We all sat down and you do that. Negotiate out. Right. And now we'll just dump it and start charging this guy all kinds of money. And then we'll ignore his letters.
Right. So, at least one thing that they're learning is that they cannot ignore the judge. And that's why we also recommend that if you're going to go and ask for a mortgage modification, that you do it through an attorney.
Absolutely.
With the court supervision of the process so that your rights are protected. And if you remember, Bob, when we modify mortgages, we bring the payment of the mortgage, the principal, insurance, interest, and all that should be no more than 31% of your gross income. Mm-hmm. So if today you're paying more than 31% of your gross income on your mortgage, including your homeowners association, your interest, insurance, all that, if it constitutes more than 31% of your mortgage, of your gross income, you may be able to modify your mortgage. Again,
I remember the number from 2 weeks ago, 31%. You said one other thing I think is real important before we run out of time, and that is documentation. I suspect when you start talking to these people on the phone, exchanging letters, you keep the letters, but when you start talking to people on the phone, it's probably not a bad idea to keep a diary.
Of course not. It is important for you to document your conversations with the mortgage company. And we do that too in the law firm. We keep records of the conversations that we have with the mortgage company.
Yeah, but you're smart. See, the rest of us are sitting out there. We're talking to the bank, and we're not thinking. And it makes a lot of sense to pay attention. And write it down. What was said. Right. So that you can't have it used against you next time, or they can't lie.
But you want to have the security that there is an attorney representing you, that there is a judge enforcing agreements so that you are protected, that your home is protected. And that's what we're here for. We're here to help you protect your home and help you save your money for important things such as food, your children.
Yeah. All the rest.
Medicine, and not just creditors who are calling you with nasty phone calls.
Ziona Kopolovich's office is located at 5422 Trouble Creek Road in Newport Richey. It's the Debt Relief Law Office. You'll see the sign. It's in Newport Richey. Her phone number is 727-849-3328. You can also go online to, is it Assist or Assistance?
That's the email, actually. Assist at
Debt Relief TampaBay.com. Okay, well, we'll see you in 2 weeks.
I'll be happy to be here.
Thank you, Ziona. Thank you. And join us for another Debt Relief Radio Show.